Good morning, chairs, ranking members, members of the Judiciary Committee. My name's Carl Schissel. I am the Senior Director of Regulatory Advocacy at the Connecticut Hospital Association. I'm here testifying in support of Senate Bill number 1329, this bill you were just talking about. So let me cut to the chase on this. When the legislature enacted Section 52-225A, it sought to achieve an equitable balance between barring plaintiffs from recovering twice for the same loss, on the one hand, and preventing defendants from benefiting from reduced judgments due to collateral source payments on the other. So the Marciano decision, in my opinion, exposed, and frankly, the unanimous court's strict interpretation of the statute that was created here, that decision, in my opinion, exposed an inequity in the law where the plaintiff can negotiate down a payment obligation with a creditor and reduce its actual economic damages and then collect the full amount from a defendant for sums it didn't actually pay. So for me, the policy decision is, what does the General Assembly think should be included in their definition of economic damages? And CHA and our members, including Stanford Health, take the position that economic damages should equal actual damages. The plaintiff should be reimbursed for an expense that it incurred. So to our mind, that should be the goal of Section 52-225A, and that should be the intent of the legislature. And if you enact Senate Bill number 1329, you will be adopting that policy and sending a message to the court so that they can interpret your law in a manner that achieves what we think is an equitable outcome. So that's our take. And by the way, thank you to the committee for raising this bill again. We think this is the 5th time in the last 6 years that you've considered this bill. And I did want to close by I did need to put on the record, and it's in our written testimony. There are arguments made every year against this bill. One is that it's an insurance industry proposal. Well, it might have been in 1986 when tort reform was enacted, but it's not anymore. In our testimony, we indicate that 62% of hospitals, the claims that are settled are through self-insured or reinsured entities. So the role of the commercial insurance market in this is well diminished since the enactment of the law in 1986. So it's really more a healthcare cost issue than an insurance issue. So I just wanted to, and it's reflected in our testimony. And frankly, there's some other arguments addressed there as well. So I'll stop there and invite any questions or comments or discussion on our take. Thank you, Mr. Chairman.
Yes, Senator Kissel.
Thank you, Chairman Staffstrom. Attorney Schissel, Carl, it's always great to see a constituent here before us, and the former House Chair of the Finance, Revenue, and Bonding Committee. I appreciate your arguments, and you did a fabulous job, and I certainly will take it into consideration, but thank you for testifying. Thank you, Mr. Chairman.
Further questions or comments on this? If not, Carl, thanks for being with us.
Thank you, Mr. Chairman. Thank you.